Scott.heisey. Scott is making a name for himself in the title escrow industry. After 40 years, he's now a sought-after public speaker. Scott, welcome to the program.
Thanks, Pat. Glad to be back.
Can you tell the audience a little bit about yourself?
Sure. I just celebrated my 40th year this past October, and I can tell you that the previous 30 years did not prepare me for the last 10 or so, and it's specific to the topic we're going to cover today.
Fantastic. I know you are speaking now to attorneys.
Yes, this is correct. Just this week, I spoke in front of the Contra Costa County Estate Planning Bar Association at their request, which was very nice to be invited.
One of the themes of this program is consumer protection and risk management, especially for the older adults. Now, financial elder abuse with regards to real estate is a booming business. Scott, I'm going to read the title of your slide deck here. Trust issues, incapacity, and the abuse of seniors and vulnerable adults. Now, I know you open your seminar with a particular theme here. May I ask you to do that again here?
So I usually start with, how did we get to this point? And as I said, the first 30 years didn't prepare me for the last 10. The last 10 is really predicated on the baby boomers, the greatest generation type of situation, outliving everybody previous to them. So what do we see exponentially is if you live longer, we're going to see more incapacity. The more incapacity we see, the more opportunity to target them. And the reason to target them for that is because as a generation, they hold more equitable wealth than the rest of us combined.
Okay, that leads into one theme in your presentation is, why are seniors a target?
What's interesting is that here's another kind of tidbit. The seniors, the baby boomers, had children. Those children may have grown up and moved away. So now the seniors are left alone, or to have a caretaker take care of them, which then, if you go through some of those other slides that I have, demographically, caretakers are now moving up the ranks of abusing or financially abusing elders, right? So there's a cause and effect happening here that I think we need to recognize, understand, and then see if we can help bar those things from happening.
Now, you have a slide here in terms of the age range of the 2020 U.S. population. And we have almost 46 million Americans 65 years or older and growing. You joke in your presentations that we are making new ones every day.
It is funny, Pat, is that it is a bit tongue in cheek, but old people were making new ones every day, meaning that the over 65 crowd is growing exponentially. Therefore, they're going to become more and more targeted because of the assets they hold.
There was a number there a few years ago that 10,000 Americans a day were turning 65.
And what's interesting is that statistically, they are becoming larger and larger targets from several different places, right? So it could be scammers, like cold calling scammers, selling life insurance or selling things they don't need. The other part is that since they are growing older and living longer, they're falling into this incapacity at an alarming rate. And therefore, their kids are generally outside the house and not taking care of them directly. So what happens? They hire somebody to take care of their parents, thus leaving that person in charge of everything. And then here we go down the rabbit hole. The caregivers are now rising up the ranks exponentially and again, demographically, as the ones who are attacking the elder people. If you have a moment, I can give you a great example of what just happened a couple of weeks ago.
That'd be great. Let's do it.
So had a transaction that came to me, and I received a call from a real estate agent saying these exact words: Scott, would you insure this transaction? Which to any title professional should be a huge red flag, because generally you open up a transaction, Pat, and it goes through and becomes a preliminary report. You review the preliminary report, and then it's underwritten from that aspect. But to have that question asked before the transaction is opened tells me that it was actually rejected before. So in real time, I have the agent and the proposed seller on the phone, and I'm punching in the data and looking at the property and reviewing the chain of title. I was the fourth title company that was involved in this transaction. So the red flags are flying everywhere. This tells me that's been rejected repeatedly. So I asked for a copy of the trust, again, with the agent and the seller on the phone, reviewed the trust, which in the trust, the two beneficiaries were the children, and they were successor trustees, a boy and a girl. The other part is that there was a newly executed amendment to that trust, eliminating the son and daughter and appointing an unrelated third party to now control the assets of the trust. Very interesting. And you could tell they were not related in that manner. So I said, this is great. I will consider insuring this if the son and daughter participate and bless this transaction, because this is all on behalf of their father, who is 96 years old, by the way. The response back from the seller, who is the caregiver, was ballistic. Told me, no, they're estranged. They haven't talked in years. Lots of other excuses. And I said, well, I still need them involved or we cannot go forward. They told me they'd get back to me. End of conversation. However, during that conversation, I did Google both the son and daughter's names, located them, daughter in Arizona, son in Texas. I was able to find their numbers in Google and call them and give them a bit of a heads up and say, hey, these are things that I'm seeing. I'm just giving you a heads up as to the potentials here. The daughter told me that they had hired that caregiver to take care of their father at a very expensive rate. So not only did they hire the caregiver, but they hired the person who was actually going to try to take the property away from them. Here comes the real punchline, Pat. I told them, look, get an attorney or somebody needs to come out here and take care of your dad. I can't go any further. I ran that property 4 weeks later and a sale did happen. That scammer was able to sell the property. The transaction was moved to Southern California. Yeah. The transaction was moved to Southern California, where it closed in a matter of days with a cash purchase of a property flipper. That cash purchase, by the way, because the property was free and clear, was $2.9 million. That's what was lost by the son and daughter by not checking in with their parent or keeping their thumb on the pulse of his situation.
And that is a tip of the iceberg, of course,
Right.
in America, right?
And I know, Pat, if I'm seeing it, every other title company is seeing it as well. It's not just I'm the magnet for these transactions. This is becoming epidemic in our generation.
And that's a case that we know about. A lot of unreported financial elder abuse is happening.
Yes. And some of those signs, Pat, are alienation of affection, where a third party comes in and separates the elder parent from their children or grandchildren and
Yes.
alienates them and creates enemies out of them. And therefore, but the problem is that those children need to react to that to stop this from happening. And basically they're being apathetic to the situation.
There's a saying that for those of us who work with older adults, it's whoever has that senior's ear is controlling the situation at the residence.
That's absolutely true. Absolutely true. And then again, in this case, and in many cases, it is the children who think they're doing something for the positive by hiring a caregiver who's then exploiting that opportunity.
Yes, I had that in my old neighborhood. Same thing, hired caregivers out of Craigslist. And they ran up the credit cards and had a relative redo a perfectly good driveway, tens of thousands of dollars. So really have to vet the caregiver. Now, what I'd like to do is part one of your slide deck here and get into some specifics. Red flags of abuse, removal of elder's name from title to property for no apparent reason. Property is free and clear.
Again, we go back to the demographics of the baby boomers, where they have a lot of equitable interest in their properties. Again, that case that I just mentioned was 2.9 million, right? In this case, if we see a wild deed in the chain of title that is from that elder person, let's say in their trust, to an individual, and it doesn't have any logical reason to it, in particular, if it's to a name that is not related to the homeowner itself, red flags, and we should stop, because that could very well be a fraudulent deed or forgery. So again, this is what title insurance is about stopping that from happening, because that person who received title through ill-gotten means, right, is going to then try to sell that and legitimize that through a title company. And that's where our stopgap should be. We need to catch that, push back, and legitimize that transaction.
Okay, for the lay people in the audience, you mentioned wild deed. What is a wild deed?
Wild deed would be one that is nonsensical, not insured, so it's not stamped by a title company, red flag, or perhaps not handled through a law office or an estate planning attorney, which we could then turn to and say, what was the reason for this, where we could get the breakdown of that. I'll tell you, generally a quitclaim deed, generally handwritten deed, it's done hastily. It looks like it's done on somebody's kitchen tabletop. These are all red flags. We put in that stopgap to go back and legitimize that transaction of conveyance of title.
Speaking of breaking it down for the top 6 list here of part 1, let's break down what is a deed in reference to the ownership of the property, and where is it recorded and why?
That's a great question, Pat. So a deed would be, let's say I'm going to use you and I as an example. I'm the homeowner of a property. Let's use you and I as the example, Pat. I'm the seller, you're the buyer. We enter into a contract and we agree upon a price, with $100,000 in this case. I sign a grant deed as the grantor to you, Pat Kapowich, as the grantee with the legal description on it. And we take that document and record it at the county recorder's office. That shows that there is a pass of my asset to you. So it's as if I'm handing you the dirt to the property. Let's put it in those really layman terms. But that should be handled through a title company or an escrow process to then make sure that the funds are transferred correctly. We're not doing anything illegal. It's all above board and it's within a contractual bubble, right? Now let's go back to the wild deed thing where I agree to sell you the property. We do this at the kitchen table and you hand me a suitcase full of money. That could be potentially illegal, could be potentially fraudulent, right? Because why are we circumventing the normal process in that case? But then we take it one step further, right? I am somebody who's pretending to be the seller. I am not this guy. And you're the victim in this case, by the way, because you bought that property from me, assuming I was who I said I was. And this is where we get into that wild deed situation. We have an elder homeowner in a trust who conveys to me, Scott.heisey, for no apparent reason. And then I convey to you for a large amount of money, right? Now, that second leg that I talked about being the conveyance from me to you is the one that's really going to be legitimized because you want title insurance. So we leave it to the title companies to catch that oddity before this. And again, in this case that I just told you about with the 2.9 million, the title company in Southern California had multiple red flags and yet ignored them and powered that transaction through, which is just mind-boggling to me.
Now, here in Northern California, we have an escrow office, which is often under the umbrella of a title insurance company, correct?
Correct.
Okay. And the escrow office, escrow officer, escrow paperwork, escrow money, they handle the transaction. Given your example, they deal with the buyer's deposit, down payment, bank, and the county courthouse for recording the deed.
Correct.
All right. So they are in the middle there. Now, when you say title insurance company, do you often blend the two together because we are in Northern California?
In Northern California, title and escrow are generally under the same umbrella, the same brand name. And I work directly with those escrow officers, which are, again, really good stop measures, right? They'll call me and say, hey, I think there's something funny going on here. Can you investigate it? Which I'll do. But I think where you're going with the point is in Southern California, Pat, title and escrow are separate. They don't work under the same umbrella. Matter of fact, title companies solicit independent escrow companies as the conduit for business from real estate agents. And
Yes.
The payment structure in Southern California is a bit different, where title officers may be commissioned, which would then maybe put their scrutiny of a transaction in question, depending on how it's going to lie in their pocket. And
That's a good point.
And I think that's what may have happened in this case.
Plus, there's a breakdown if they're different entities. All right. So now coming up next, red flag signed power of attorney that neither appears properly executed nor specifies the authority given to the attorney in fact.
That's become a huge thing, Pat. Powers of attorney, we have to scrutinize them very tightly. I'll give you a couple of really interesting examples where we're getting handwritten powers of attorney, or they were clearly created on somebody's laptop with language that isn't consistent with the statutory forms, right?
Now, may I ask you to describe for the lay people?
Sure. Power of attorney is essentially giving an agent, attorney in fact, which would be, again, an example. I have to leave town. Pat, I need to execute a power of attorney. I'm going to appoint you as my attorney in fact to do the things on my behalf. Now, in a specific power of attorney or even a general power of attorney, there are typically box checks that I can either give you full authority or limit your authority. So let's say in this case, I'm leaving town, but I need to sell my house. I trust you. I give you a power of attorney to only sell the house, anything related to the sale of the home. And then you would execute that transaction. You would sign my name by Pat Kapowich as his attorney in fact. Okay. Thing is, we would have to legitimize that power of attorney. Matter of fact, in a transaction, I would be at the title company using their form, which is already approved, appointing you, establishing that we have a relationship. So therefore, we've already created a legitimate transfer of power. In cases where elder financial abuse exists, there would be a power of attorney that was executed, again, generally recent, right? Let's say 30, 45 days, in which, let's say you, the agent in this case, the acting attorney in fact, is now exercising immediate power to sell a property. So we're putting the time out on that. We go back and say, wait a minute, Pat, how are you connected to this person? You go, I'm the caregiver, red flag. It's not acceptable at that point because you are breaching basically that confidentiality, right? Somebody puts you in charge to take care of the parent, not to sell their assets. So that's a different thing. In many of these cases, Pat, we already know there's a power of attorney that's of record, maybe not of record, but in the works that was executed prior to the elder person becoming incapacitated. So anything after that one would be suspect and likely executed while the person had incapacity, which then voids that document altogether, eradicates the powers issued under that power of attorney back to you in this case.
There seems to be two ways to do it. Caregiver or wayward adult sibling bring the elder in and do a power of attorney in front of an escrow officer, even though that person that drove the elder to the escrow office has no business in this capacity as a fiduciary or a person of responsibility, but they do it in an office. That could be tricky too.
Oh, agreed. That's a great point, Pat. And think about how an escrow person or a notary is put in the line of fire to establish capacity of an elder parent. And some of the things we would need to watch out for is that, let's say, son or daughter hovering over them, explaining to them what to do, or pressuring them into signing something. A notary should not bend to that at all, should reject doing that notary. Okay, but let's go down that rabbit hole for a second. If somebody's truly committed to taking advantage of an elder person, whether it's a son or daughter or a caregiver, they may just sign the document on their behalf anyway, fake the notary. These are the things we run into.
I see.
Absolutely. Fraudulent documents. We do run notaries' names to make sure that that notary is local and that their stamp exists, or was it pirated in some way? The links that we have to go to legitimize a transaction for an elder person is extreme. And I think we actually go further as an industry than most of the district attorney's offices in all the surrounding counties in the Bay Area itself. And I've called most of them and talked to them. They agree this is epidemic, but they're horribly understaffed to deal with it in real time.
Yes, I've been to one of their seminars, the FBI white collar seminar, and they mentioned that they are understaffed.
Yes.
At that time, they did not want to put resources to a case unless it was over 100,000 loss, right? Okay, so coming up next, red flags of abuse. Property has been owned for a long period of time by the same grantor.
So that one is very interesting. Again, here's the signs that we look out for or should be looking out for. When the elder person acquired title, and again, in that case that I told you about, had bought the property in 1962. So we know that. Some of the other signs that we might see or understand that the age of the owner of the property would be the establishment of maybe a trust in the 1980s or 1990s gives us an instant clue as to the age of that party. So suddenly we've got an elder person or somebody's held title for a very long time, let's talk about 30, 40, 50 years, right? There's no loans on the property. So we know it's liquid equity right there. So if you transfer the property, it turns into instant cash. And then suddenly there's a transaction. Our first questions should be, where's mom or dad going? Are they being transferred to an adult living facility? Have they passed away? Because of record, they're still alive, but there's suddenly a transfer or a power trying to sell the property, either under the authority of a trust. And many people will think the property's in a trust, it must be okay. But trusts can be circumvented, right? As in the case I was telling you about where the caregiver came in, they circumvented trust. They altered the trust by doing a new amendment to that trust. And reading that amendment, it was obvious that it was not drawn by an attorney because it was so self-serving. I hate to say it, there's no magic cookie cutter way to check these things out, Pat. Every transaction is different and every fraud acts in a different manner. We have to be diligent at looking at these things.
Now, on your slide deck, red flags of abuse, I know you recently spoke with the Bar Association in one of the counties here in Northern California.
I did. It was the Contra Costa County Estate Planning Bar Association. And they invited me to speak on what I run into on this and many other topics related to trusts and incapacity.
Now, let's do a few of the bullet points.
All right.
Request to disperse sale or loan proceeds to someone other than the owner of record, the borrower, or the seller.
That's an interesting one because, again, that tells us somehow the trust or the situation has been circumvented by potentially a stranger trying to come in. And I'll give you the 411. If a property is in a trust, the title company should be dispersing to the trust account and then placing the further distribution into the hands of the trustee of that trust that would go out to the beneficiaries of the trust, being that, let's say, Pat, you and I are two brothers, our parent passes away, you are the successor trustee of that trust. So therefore, you drive that transaction to sell the property. You are held accountable to me as a beneficiary of that trust. So when the transaction closes, the proceeds go to the trust account. You as the successor trustee are now in charge of distributing those proceeds out, potentially half to yourself and half to me. That's how it should go. But what if it was the same situation, but you instructed escrow to send all proceeds to the Pat Kapowich account, therefore circumventing me and the trust itself? So that's a huge red flag. And historically, here it is from the data, sons are more likely to take advantage of the parents' assets or trust account more than daughters. So keep that in mind if anybody's listening or watching this, is that if you have a son or daughter, you're statistically more protected by appointing your daughter in charge of your estate.
That's a good point. Let me go to that slide. Speaking of which, we have the 3 top groups targeting elders. Family members, Scott.
As I just mentioned, so if we're breaking it down to family members, sons over daughters are more likely to take advantage of the estate of their parents or grandparents. Daughters fall into second position, grandchildren into third position. Then falling down in succession, it's telemarketers, scammers, door-to-door knockers trying to talk the elderly person into unneeded home repairs for exorbitant amount of money. And then that third one on that list is caregivers. But it's really the caregivers that are coming up that ladder much faster. And I think will actually circumvent a lot of the children or grandchildren in the next 5 years. And I can give you a reason why that is because the elder people are being moved into facilities, elder care facilities, or they are being handled by, again, hired help, hired caregivers who now have 24/7 access to that person to manipulate them into rearranging the structure of their trust or circumventing the trust and doing things like wild deeds, where the deed goes from the homeowner to the caregiver, which we have seen from time to time. That one's coming up rapidly. And again, it's a sign of the times as to where we are evolving to put our elder people into assisted living facilities.
Now, let me close this out, this segment here, because you had under family, number one, it is 24% adult son, 20% adult daughters, 15% adult grandchildren, And then number two, fraudsters and professional criminals, home repair scams, telemarketers, 12%. The third category, friends, caregivers, and others in position of trust, 8%. And that's where you mentioned the fastest growing offenders. Next up, red flag of abuse, legal documents in which the notary did not witness the elder signing.
That one's a great one, Pat, because in California, we generally will not accept a witness acknowledgement, right? So in this case, I'm the elder person. You're trying to scam me. So you get my signature on a power of attorney or a grant deed. And then you go to a notary to say, I witnessed this. You're signing an affirmation as a witness under a witness acknowledgement. That has pretty much been eradicated in the state of California, certainly for title insurance purposes. Now, there are other cases where that might be acceptable, but I do not believe a title insurance company would accept any of it. And that document, if the person, me in this case, were still alive, we'd probably have to have that person evaluated and maybe a court to confirm that you are now in charge of my estate, right? And it's becoming much more convoluted. Why? It's because we've seen that drastic uptick in fraud, forgery, and elder financial abuse to where what we did more than 10 years ago is no longer acceptable today.
Red flag of abuse, transfer on death, another acronym for our business, TOD. Deeds for an elder not yet deceased. In other words, the homeowner is still alive.
It was the transfer on death deed law came into effect in January 2016. And it was really promoted with the absolute best of intentions. And that was to help people with limited means not be burdened with setting up a trust, which would cost them several $1,000s if they only had one property and potentially one beneficiary being a child or a grandchild. That's really what the nature of that was set up for. However, what happened shortly after 2016 before it ramped up? COVID. So now we had COVID. COVID really hit the elder population quickly and hard. And it forced children or grandchildren to go, hey, mom, dad, grandpa, do you have a will? Do you have a trust? Do you have anything? And of course, they did not. So a lot of these were being executed in the hospital. Many of them were executed literally hours before the person passed away. They're on their deathbed. And so in these cases, it couldn't really be validated the capacity of the grandparent or parent signing. So those became void right off the bat. And I can tell you, we had a huge slew of those things come in 2020, right? Shortly after COVID kind of started to wane a little bit. I can tell you out of, let's say, the 50, 60, 70 that I encountered, I was able to really only pass through on 2, 3, 4 of them, maybe even 5% total. So
Wow.
That's a big issue there. But again, it was set up for the best of intentions, but its misuse has become the big issue.
To clarify, can you give us an example of a perfectly legitimate concern?
Sure. So again, since we're on camera, I'm going to use you and I as the catalyst here. I'm the parent. I have one property. You are my son. This is a very logical thing. I have capacity today. I don't have any mental illness, but I am getting older. So what do? I execute the transfer on death deed to you. It reserves my life, right? I get to live there for the rest of my life. But when I pass away, you record that death certificate, thus transferring title to you, avoiding probate. That was absolutely what it was set up for, not the knee-jerk reaction to imminent death, which is what it was used for. Or, I hate to say it this way, I'm the parent, you're the child, but you have 1 or 2 brothers or sisters, but I leave that property to you and they don't know about that. Okay. I pass away. Those 2 siblings argue capacity saying dad didn't have capacity to leave it to Pat. So what title insurance company is going to want to get in the middle of that defense? We don't. So we're going to look at all of the circumstances surrounding the execution of that TOD. And if we do discover there are other siblings involved, we may ask for their consent. Hey, are you okay with Pat having this property? And please give us that consent in writing to us. Then we start to legitimize things and realize that we are tying this up into an insurable transaction as opposed to a potential lawsuit arguing my capacity after the close of escrow.
Fantastic. Red flags of abuse, Check signatures that do not resemble that of the elder on recorded documents.
But that is a really difficult one to discern. And of course, we are not forensic experts, right? But if there are suddenly drastic changes, and we do look at all of the documents in the chain of title historically, so the parents acquired title in 1980, they have a loan in 1980, we can check signatures on that. They deed to, let's say, their trust in 2000, and we match that signature against their signatures in the 1980s and go, okay, we can see consistencies or maybe a little bit of a change there. But when we see a document executed, let's say more recently, the last few years, and it's extremely shaky, it's not across the signature line itself, maybe it droops down or droops up, that would give us pause. Now, that doesn't mean that the person's incapacitated. Potentially they had a stroke. Maybe they're absolutely clear of mind, but they are shaky, or Parkinson's or something like that. We have to dig into those facts to then legitimize that conveyance. And I hate to say this, but we reach out to somebody who's representing that elder person, a child or what have you, and we require doctor's letters to legitimize the capacity of the parent themselves, even though because aesthetically they look like they're incapacitated because of that signature line. Again, we go to these extremes to protect the elder person, right? And it's very important to do. Now, if children would push back and say, I don't want to get a doctor's letter, I would ask them why. Why would that be a problem? Obviously, your parent is seeing a doctor on a regular basis. Getting a simple letter for evaluation purposes is really not a burden. So that's a huge red flag when I get lack of cooperation.
Now, is that typically one doctor or two?
Trusts, Pat, are generally set up. The clause in most trusts deems that two unrelated yet licensed physicians validate the capacity of the elder person. In this day and age, it's a little tough to get two because nobody sees two different doctors for the same ailment. Right. Now, if they go to a practice type of thing, Kaiser's pretty good because Kaiser works in more of a pool fashion. So we can get letters from them, which is great. And they respond very well and they have a statutory form, which we understand. But more of a private practice might be just one doctor. And so we have to weigh that and make sure that the doctor isn't a niece or a nephew or somebody related here, that they are absolutely arm's length away from this transaction. And then we weigh that evidence against the situation itself to legitimize it.
Understood. Scott's red flags of abuse. Property has been owned for a long time by the same grantor.
That's generally a red flag because if they've owned the property for 30, 40, or 50 years and it's being sold now, what's the specific reason for it to be sold? Is it to move that elder person to an assisted living facility? So we need to check that out. Now, if they've passed away, that's something we can deal with and handle. Hopefully they're in a trust and the trust outlines who the successor trustees are. And we go through that, basically the menu that is laid out in the trust and follow those terms. However, what if it's just an elder person who acquired title as husband and wife as joint tenants back in 1962, is today a widow or widower? Now we're looking at a probate. Of course, then we have to go through those parameters. Did they have a will? Were they testate or intestate, meaning that they had a will or did not have a will? Where do we go from there? If I find out, no, mom's still alive, but we need to move her to an assisted living facility because she's in her 90s, okay, that's fantastic. But she's the owner of the property and that's turning into a huge amount of cash. Who is monitoring that cash? Now she's incapacitated. We may actually require that they get a conservatorship set up so there's a way to monitor those funds in favor of mom's care. And we have to keep that in mind. And I'm going to say this kind of out loud in front of your crowd, which are by and large going to be real estate agents or brokers, that everybody should be reading that preliminary report on that property when it's hot off the press. And I can't tell you how many times real estate agents tell me, no, I don't read it. I have my escrow officer read it, which is fine, but that could delay showing of problems, right? Or the escrow officer may be too busy to actually catch the nuances here.
For the lay people, what is a preliminary title report?
So a preliminary report is the status of title. It's an opinion of the title company of what is encumbering that property. So we'll show the taxes, right? We'll show the legal description, we'll show the loans against the property, and we'll show the easements against the property. But really where it's important to the topic of today is the vesting, the owner's name on that title. And every agent should look at that, look at the name on that title. And if it is not the person that they were dealing directly with, then they have to stop and ask themselves these questions, or ask that person, who are you? How are you related to the owner of this property? And under what authority are you able to act? And that authority would be power of attorney, right? If it's in a trust, are you a successor trustee? And in this case, many times, Pat, they say, Mom had a trust, but the property's not vested in the trust. Something's missing. We need to get that property into the trust if one actually exists.
Excellent. Red Flags of Abuse by Scott.heisey. Assign power of attorney that neither appears properly executed nor specifies the authority given to the attorney in fact. Okay, please. First, what is a power of attorney and attorney in fact?
So those are related terms. The power of attorney is the document that exchanges the power or promotes the power. So I'm the elder person. I execute a power of attorney. I make it in favor of you, Pat. You become my attorney in fact, right? So everything you execute is on my behalf for my benefit. And it can't be self-serving. It can't be for your benefit. So when we're looking at powers of attorney, if one is very broad in scope, let's call it a general power of attorney, and it grants Pat Kapowich 100% power over everything in my life, we're going to scrutinize that very heavily. In real estate transactions, we much rather use a special or specific power of attorney related only to the sale of the property, where it limits your powers to only sell the property itself and doesn't extend beyond that. That's our preference. However, let's put it in context of elder financial abuse or just the elder community at large. Many times we're seeing durable powers of attorney, which last a very long time, right? You execute it one time, it's supposed to last the rest of your life. It specifically drills down to powers that you would have in this case, Pat. If I was your father and executed a durable power of attorney, you could deal with my medications, doctor's appointments, pay my bills, basically take care of everything that I would need to do to stay comfortable and alive, with the exception of sell the property. Now that would have to be specifically written into a durable power of attorney. But by and large, if the property's in a trust, I set up my trust, my assets, my home, my cars, all those things are in there as assets, then a durable power of attorney is created as almost an addendum to the trust to handle everything outside of the trust itself, meaning non-tangible items, more personal issues, right? But in both those cases, you are my attorney in fact. So you would execute everything as Scott.heisey by Pat Kapowich, his attorney in fact.
Fantastic. One follow-up question. Can you give an example of financial elder abuse with the power of attorney, real world?
Yes, I recently came across an issue where the elder person lived in Santa Clara County. And obviously the property is worth a lot of money, again, free and clear. His son, his only son, lived in Alabama. So we have a disconnect between father and son. A caregiver was hired to take care of dad. And suddenly a newly executed durable power of attorney shows up, and wherein the caregiver was tapping into the elder person's bank account. Now, there is a civil code provision that states that unless you are aware of the misuse of this power of attorney as a third-party recipient, you cannot deny the use of that power of attorney. So the bank could not turn this person away because they had no actual knowledge of it being fraud or forgery. You see how that opens up. To expand upon this situation, the caregiver then also started using that durable power of attorney for other things, right? Kind of tapping into the account, using it for personal, basically their personal bank account. The property was in a trust, and they also altered the trust to put themselves in charge of the trust. In speaking with the son, there was suddenly an alienation of communication that happened there, and it happened rapidly. It was within 45 days of employment of the caregiver, and suddenly years of communication was wiped out in a matter of weeks. He talked to his father briefly on a Wednesday and was notified on that Friday that his father had passed away suddenly. I had the conversation with the son on Tuesday, and he did tell me that the caregiver was trying to acquire the body of his father to cremate immediately.
Oh, wow.
So this is probably the most egregious one I've seen, but it started with that ill-gotten power of attorney, and they tested the waters. Hey, can I get a few bucks? And then tapped into the well quickly, changed everything and to make a quick exit, and was trying to then sell the property immediately. And of course, the son did not know what to do. And again, this is where smart fraudsters can rely upon the fact that the kids cannot believe this is happening, and that they stall and they pause. They may become apathetic to the situation. What can I do? Doing nothing is not an option. And again, I'm notifying people. And by the way, you being a real estate agent and a broker and a title person or escrow person, we are not obligated to notify the district attorney's office, right? We're not mandated whistleblowers, but we see it more than everybody else. And
Yeah, that's interesting, isn't it? That
it
we're
is.
not mandated, although there's nothing wrong if we see something that appears to be criminal to call the DA's office, or every county, I think, in California has a financial elder abuse.
Most of them do, but again, they are horribly understaffed. And again, what's very interesting about it is that I'm seeing it so often that I know my brothers and sisters who are entitled must be seeing it as much as I am. If I look at that exponentially, where a big part of my week is dealing with nothing but this, then a big part of their week must be that. And how often is the district attorney's office actually being notified of these things? And then would they staff accordingly? I don't know. And it's so sad, Pat. It is absolutely heart-wrenching to run through this.
I used to describe this as the biggest unknown crime in America. After speaking with you today, perhaps it is.
I agree. It's certainly, and by the way, it's a trend that will not go the other way. It's trending up. And it may level off at some point if we can get some real legal action happening here and some teeth to this. But until that happens, it's just going to keep going up, because again, the old people were making new ones every day, which means every day there's a new potential victim out there.
Scott, on behalf of the community, thanks for raising these concerns throughout Northern California. I will put your contact in the show notes, and I'm looking forward to you coming back for part 2.
Great. Pat, thank you so much for having me, and I'm looking forward to speaking to you again.
That was Scott Heisey, part 1. Be sure to tune in for part 2. He's one of my latest heroes, mentors in the real estate arena.